Good morning, gang. How's everybody doing? Everybody's all right?
Excellent.
All right. No, you're going to be upset, but Wendy's not here today.
I'm calling her at 10 p.m.
The good cop is on vacation, so you're stuck with the bad cop here, you know? So if you need her over the weekend, don't call her. Don't text her. Leave her alone, please. Call me, call Jeff, call Mark. I'm sure it's we could handle whatever your thought or concerns might be. Let her. I think she's in Utah. Utah?
Yeah.
What's in Utah? What?
Hurricane.
Who?
I think it's a UTV, like,
Yeah.
camp out.
RV kind of thing? Oh, wow. Good for her. Okay. Before we get to these, do they look like lawyers? What do you think? Yeah. Kidding. Just messing with you. Yeah. But three really good guys, Jeff, Andrew, and Lucian. They have a nice PowerPoint, talk about some stuff. We're not going to really talk about the lawsuit. Not that we don't want to, but it's been what, 2 months? What's today?
Yeah, 2 months today.
To the day.
Wow.
And what do you think?
Nothing's changed.
Nothing changed.
Right?
Yeah.
We all thought the shit was going to hit the fan, and people are going to jump off buildings, and clients aren't going to pay us, and no one's going to sign this, no one's going to sign that. And a lot of it has to do with you guys, particularly on the selling side. You've done a good job of explaining to the seller that, look, you don't have to pay the commission, but you might want to, like we've done for 100 years. So maybe this wasn't quite as horrific as we thought it would be. So, but they're going to talk about some other stuff. They'll tell you what they do for us. Okay, they work for the company. Some agents come up to me and say, you know what, Tim, I got a legal problem. Can Realty One attorneys help me? I don't think so. Probably not. For your personal stuff. We pay them to represent the company and represent you when you get into some hot water. So that's where your E&O money goes to. Okay, so let's show you some more stuff. All right, there's Lucian. We didn't have Jeff and Andrew's photo, so you're stuck with Lucian for now. Stacey's going to talk in a minute. Where's Stacia? Is she hearing that yet? There she is. Beautiful breakfast. What'd you bring today?
There's fruit, so there's
Fruit?
plums and mandarins and grapes, and then there's big muffins that are either cranberry orange, apple spice, or pumpkin.
Wow.
So
Okay.
it's a little seasonal.
Kind of good, bad, sugar, fruit, all that stuff. I like it. Okay. This Sunday, from these hours, do not come in the office. The furniture's going to be moved. They're Zamboniing the floors. If you're a hockey fan, you know what a Zamboni is, right? They're going to get that big machine and clean all the floors. So don't come in on Sunday. Or come in at, 6 o'clock, after 5? Go visit Jeff and Mark and Jim. Use those offices, okay? If we could lock the doors between those hours to keep you guys out, we would. Because we know you're not going to listen. You're going to show up anyway, and the cleaning people are going to be bitching and moaning to me. So, Tim, you got 14 agents here. It's Sunday. Why didn't you tell them? Just try your best not to come in, please. On another note, that's the next one. I was on this yesterday from LVR. It's a new thing called Cuba Casa. You all should look into this. It's free. How many of you on the listing, as part of your photos, get a room dimension or 3D, right? Not everybody does. It costs a couple more bucks for your photographer. Here it's free through LVR. So look at it. They do have some stuff you can buy. There are some upgraded stuff, but the actual floor plan is free. So you might want to hop on one of these. It was like a 30-minute webinar, easy to do. I went home to my house, took the phone, did what they did, and it gave me a floor plan of my house in like 10 minutes. Really, really cool. Okay, kind of nice. Okay, so Cuba Casa. Okay, on a different note, since November of last year, Kathy Little, Rosie Harsh, Cam Husted, Sveta's sister, Michelle Drinks, and now Ampelio have died. It's crazy, right? Crazy shit. We're all getting old here. We're all getting old. I don't know if you know who Ampelio was. He actually was a realtor in California, but he was Lori Wayne's husband. He was the guy that was out here all the time. I used to call. Yeah, he died. I used to call him Sasquatch. When he first came here, I said, Sue, who's the guy over there? Does he work here? She didn't know who he was either. And he'd come in every day. And he'd be on the computer and helping out Lori, but he never got licensed here. But really good guy. And he died. I don't know when, last week, had an aneurysm. And, had an aneurysm, went down, and that was it. So crazy stuff. There's going to be something we're all going to go to on, what's the date? October 30th. If you want to come, send flowers or send a donation. please do so.
She posted a link, or she's gonna send a link if you wanna watch it virtually.
Oh, wow. Okay, gotcha. Okay. So, yeah, so we feel bad for Lori. Lori's been with us a long time. He's a really good guy. I thought he was the strangest dude in the world when he started coming in. Like, who's this guy? Right? Really is, you know. A little secret around here, just so you know. Sometimes you'll see me and Wendy go up to Suzanne and go, that means a realtor walked in and we don't know who they are. Because we see them once a year or once every 5 years. You know, we have 500 realtors. You know, 50 of you come in all the time. The other 450 don't. So that's what it was with Impelio. Like, who's the dude who's the, Sasquatch here? But a really good guy. So support Lori if you can. I think that would be a good thing. Some quick stats. The numbers are going up, 8,100, 5,400, single family. This is where it was last year. So as you can see, there's a nice little increase. I think it's 34% in inventory, so that's a big number. But the unusual part, like I said for weeks, is that home values are still going up a little bit, which usually doesn't work both ways. Usually if the inventory goes up, prices come down a little bit. So that's going to happen sooner or later. But until then,
But is the home prices going up, that's because of the new homes being added to MLS? Because
well, there's a fraction of new homes added to MLS.
Right, because
I mean, a fraction. Like,
if you're looking at the reduced price on the MLS on the hot sheet on the front page, it's in the 200 to 300 range almost every day now.
yeah, but if we sell 3,000 homes a month, 80 of them are new homes. You know what I'm saying? It's not like it's 800 new homes that are going to affect the value. But you're right. The new homes are in there, but it's not a big number, okay? And the median price is still in the 480s, which is kind of amazing too. What I found interesting, there's almost 2,000 condos and townhomes on the market, which is the most I think I've ever seen. 1,800 and something this morning, condos and townhomes. That's a lot, okay? That's a third of the inventory, so it's kind of a weird thing. The only other thing that scares me a little bit, this has gone up to 38. Remember, it was 31, 32, 33, 34, now it's 38 days on the market. So, maybe sellers are taking their time. So kind of keep all that stuff in mind. That's October of last year. If you're a nerd like me and you want to compare, you can look at that. Don't forget to refer 3. Kuba's putting on a special, $1,111. One of you could win if you refer an agent in that we hire them. They're going to do this little, what's it called? Help me out. Wheel. And your name will be on there if you sent someone in. I think Haya's name is on there already. We hired someone that Haya sent in. She could win $1,100. Okay, and that's for the month of October. So Kuba's doing a little bit of a special to give you guys a couple extra bucks. We'll go through that. Here's the stats. Keep this in. You should have this with you all the time. Have it on your phone. Send it to your clients. 2023, we were the top brokerage firm in all categories. Sales, average sales price, most listings, most agents, most everything. And we've been at the top of the list probably 14 of the 19 years we've been open. So we're kind of proud of that. And we only get this once a year. This is for 2023. We get this like February of 24, so we'll get a new one February of 25 for 2024. And I got a feeling we'll probably be at the top again. So that's kind of a cool little thing. Don't forget the YouTube channel. I don't know how many we have there. I haven't checked lately. Maybe Suzanne will take a look. 200 and something of you have subscribed out of the 500. So come on, chop. How do we make money? What number do I make money from the page? 1,000. Oh, okay, we'll never get there then. Okay. All right, just a thought. Upcoming stuff. A reminder, you cannot do an open house on a RE/MAX property or a Coldwell Banker property. And a Coldwell broker agent can't call you and do an open house on your property. Rules have changed, liability, the lawyers get involved, probably, you can't.
Just stay within our brokerage?
You do.
Is that
You do.
just exclusive to Summerlin? Because I see the Southwest agents doing it.
No, they shouldn't be doing it. If you do them, tell me or tell Mark.
Is that a company policy?
It is.
I'm not
Came down from the top. Lawsuits. Coldwell Banker agent is at Arizona Realty 1. He falls down the stairs, or his client does, and it's not even their listing, and we get sued. Or something to that effect. Okay. Will this change? I don't know. It might. But as of now, don't get caught doing someone else's open house, and don't let anyone else do yours. Okay? We have 1,600 agents. You should be able to find someone to do your open house. You don't have to go to another agent, I hope, and vice versa. We have more listings than anybody else. So you should, if you want to do an open house, you could find a Realty One. Realty One has 800 listings. 10% of the listings are Realty One agents. You should be able to find one, gang, to do an open house for one of ours. You shouldn't have to go to another agent, okay? I know the benefits of doing that, and I'm with you, you know, but as of now, don't do it. If you get caught, there are going to be some consequences. What they are, I have no idea, but just don't do it, okay? Please. Next Thursday, we're going to do the chili cook-off. Summerlin, in Thanksgiving at the end of November, we're going to have the turkey, so let us know if you're coming for turkey so we know how many turkeys to order. This would be cool with the chili. We usually have 10 or 12. We have a little contest. We give out prizes, kind of fun. So who makes chili? Is anyone a chili maker? Stacia brings one. Velvet will bring one. You bring one, Tim? Yeah, I got Albert. Albert's son helps me do it. Yeah, he's really good at that. Okay, we're gonna do this. We're gonna put this on Facebook, Suze, and see if anybody wants to do a little carving thing. Okay, no one's excited about this, or you're keeping it to yourselves. Okay, you're embarrassed to raise your hand that you want to carve pumpkins. So we're gonna put this on the Facebook channel, on the Facebook page. Have a little thing on there so you can anonymously say great idea or the stupidest thing I've ever heard of. Whatever you guys want to put on there, okay? But just something different that we kind of thought of. Don't forget the Christmas party. It's only $11. It's at Santa Fe. I don't know, we have maybe 50 of you that have signed up so far. Give or take. And there's only 125 spots, okay? Most realtors wait until the last minute. Don't wait until the last minute. Or like last year, probably 30 people came up to me and Mark and Jeff, a day or two before. Oh, I forgot to sign up. Can I go? No, you can't go. It's full. I'm sorry. You can't go. We'd like you to come, but you can't. Okay, so sign up. It's only $11. That's the rev-up schedule. That's the calendar for us and a few of the other offices, as well as the cool one that Tim and Heather created for Rock Title, all the training classes that are taking place. All of this stuff is in the handout, so please take the handout when you guys leave, okay? ABR is still free. If you don't have your ABR, you should still go call up Key. Key is doing it for free. And the Northwest is doing the class, I think, in November for free. It's a 2-day class. It's usually $300, so you can get your designation potentially. Even if you don't have enough experience to get your designation, the knowledge alone is, the heck with the designation. Who cares what's on your card? ABR, GRI, doesn't matter to me. But the information is what you want to take the class for. It really, really is some good stuff, okay? If you need your photos, Sean is back. Sean Kenny. For $99 or less, he'll give you some really nice headshots. He touches them up. If anyone's a Star Trek fan, I was not a Star Trek fan. He was on Star Trek for 15 years. I forgot what he was, a Vulcan or something, or I don't know what they were. I never watched. I was not a Star Trek guy. I really wasn't. I never watched it in my life. But he was on Star Trek for 15 years. I forgot what he was. Crazy.
Make him a better photographer?
I don't know. But if you grab him. Hey, so tell me about William Shatner. Holy shit, he'll go on for an hour. What was Leonard Nimoy like? Sit down. I'll tell you all about Lenny. Really, he's that kind of guy. So.
Does work at light speed.
Oh. All right, gang. We can't do half of this stuff without all our partner vendors, and one of our favorite, of course, is from Old Republic Home Protection. You know where over there she is, Stacia Brain. Come on up, Stacia. Give her a big round of applause. Yay!
Y'all know how to make a girl feel good about herself.
I tell you.
I'm going to go back to it's just a somber thing, as you lose people and stuff. I don't know how Android phones work, but I know on iPhones that you can go in and you can update your emergency contacts. And if everybody hasn't done that yet, just do it. It takes you just a moment, and it's a really, really good idea in case you have a fall or something, and you could they have the right contacts to get a hold of people for you. So moving from that, I know that you're going to be, having some attorneys speak to you today, and I just want to talk to you once again about Old Republic Home Protection and our seller's protection coverage. So, if my app that I have is 85% accurate, it states that right now we have 174 listings for this office on the market and 55 in escrow. And as of this morning, I haven't, from October 1st to today, gotten one request for a free seller's coverage on your listings. And I'm going to take it on me to say that maybe I just have not told you properly what it is and how it can protect you from some risk mitigation, how it can protect your clients from some, costs as far as failures during the listing. And so this is my cell number and this is my email. And I know that after this meeting, I have another meeting, so I won't necessarily be sitting around for a long time. But these are numbers that you can reach out to me, and if I'm not driving and having my personal concert in the car while I'm on my way to my next meeting or in a meeting, I'll call you back, I'll reach back out to you, and I'd love the opportunity to discuss that with you, because I know that in many people's eyes, free is like this, nothing's for free. Of course, we hope that that turns into a paid buyer's policy. I mean, I'm not here to tell you that it's something, that it's not. We'd love for it to turn into a paid buyer's policy that goes on. But there isn't much. I mean, there's limits, there's restrictions. We're not replumbing a whole house, and we're not re-roofing a whole house. In fact, roofs aren't even covered in the seller's protection. But it's up to $1,500 towards plumbing, electrical, built-in appliances, so not your washer, dryer, and refrigerator, but a stove, range, built-in microwave, dishwasher. Dishwashers are our most frequent claim during the listing. I guess people use it for storage, and then when they put their house on the market, they start using it and it seizes up. And it could derail or put a crinkle in that transaction if you have an escrow already in place, and then they have an inspection and the dishwasher doesn't work. And you wouldn't want you wouldn't want it to fall off track for a dishwasher. So there's things that you can just protect to a certain limit your clients. And the sooner that you put it on as a buyer's policy for your buyers, we're gonna protect it from that point on. So like Tim said, a lot of realtors wait till the very last minute, and I do get that. We're at the signing table, Stacia, can you get me an invoice? And that's cool too, I mean, it happens. But if you go into contract and you've negotiated us in and you put it in, or you have me put it in right away, you've got that limited protection until you close. Now, it's not for the laundry list that the inspector might find. Those are now known existing conditions. But for things that just happen, because things do just happen, take advantage of it. It's free money. And it's a really good closing tool to, when you're taking a listing, to talk to your clients and just let them know that you can provide, a small umbrella of protection during their listing for failures. So if you're not taking advantage of it, my question is why? And if you haven't reached out to me about it, or you have more questions because maybe this isn't entirely clear and you just want a one-on-one, reach out to me. I'd love the opportunity to tell you more about it, see if it is a good thing for your clients, it is a good thing for you, and have nice little FAQ flyers that you can put in your listing packets. So if you aren't already working with someone that you like, trust, or have confidence in, I'd love that opportunity to run your business. Thank you so much.
Stacia, everybody. Woo-hoo! Woo-hoo! And again, if you're taking a listing, you should call Stacia and get free seller's coverage. You should use Kubicasa for the floor plans, okay? I mean, these are all things that are gonna show value to your seller when you go into them and talk to them about the commission, okay? You're not just gonna go in there and say, look, I charge X bananas. You have to build up a little value, and these kind of little things can make all the difference in the world. They really can. Real quick, little trivia. You guys know I love trivia. There's 3 numbers here. 216, 416, 616. We have some beautiful Realty One long sleeve shirts for the fall weather. How many? What's the right answer to how many listings we have in this office? First right answer.
216.
616.
416.
It's Carrie Meyer. 216. There you go. Very good. Okay. All right. One more. 147, 247, or 347. How many homes? What's our zip code?
135.
How many homes? How many single-family homes are in MLS in our zip code?
147.
Who said 147? Me. There you go. There you go. 147 homes in our zip code. Is that stupid, trivial bullshit? Absolutely it is. Okay? But you say that to a client on the phone that lives in Summerlin, they're going to think you're the smartest agent in the world. So just little quirky stuff. That's my quirky stuff of the day. All right, gang. On more important topics, there they are. The Tim and Heather Show, Rock Title. Come on down, guys. Talk a little bit. And
Well, I'm gonna let Tim talk.
You can let
He has
Tim talk.
more
Yes.
to share, but, yeah.
oh, here, you need this, and you need your.
Just briefly, but do you want to talk while I get set up real quick?
I could do that.
Something?
Yeah, I could do that. Yeah.
'Cause
Give
I
me-
can't multitask.
Yeah, oh yeah, you hold that. Make sure you take this again with you guys and look at inside. Rock Title has so much stuff going on. Tim's doing a class right after this, just so you know, at 10:30, quarter 11. Social media?
Yeah.
Social media. So hang out for that, have some more food, okay? Talk to Heather about a farm list if you want to get a farm list. But go through the 5 or 6 things they have in here that they're doing for us, okay? And as always, on page 3 of the RPA, we want you to put Rock Title and your favorite escrow officer, regardless what MLS agent-to-agent remark says. Every listing agent, including me, puts seller prefers Laura Moran from Rock Title. My seller doesn't even know who Laura Moran is. But I'm going to put that in the agent-to-agent remarks because I'm a dopey listing agent, because I want you, the buyer, to use my title company. Ignore that. Put Rock Title. Let's try to get them to earn some business from us. All right, Timmy? You got this.
Does anyone know what discount you can get on the escrow?
Oh.
30%.
30%. You're all winners, yes.
Awesome.
There you go.
Yeah, where's the
Yeah. Hey, what did you win? Yeah.
There's some nothings out there.
Well, Tim said it all, basically, so I have not a whole lot to say at this point, but thank you for that intro, Tim. I appreciate it. I've been wrestling with this. I'm going to be very vulnerable right now. You guys know me. I'm usually, pretty professional across the board. One time I threw my phone, hit the wall.
It did.
But that wasn't out of anger, it was out of frustration. So, I always do my videos. Carrie, how long do we have to get somebody's attention when we're doing videos?
3 seconds.
3 seconds. People keep scrolling while they're driving. I always do my videos at home, but this time I thought, I'm gonna drive super slow on the shoulder. So you may see me do this. And I'm gonna read from a script. Phone was on the windshield. I was driving super slow. Got automatic drive. Is this getting me in trouble? Good. All right.
You work for Rock Title, not Realty One.
So the wheels came off a little bit, not my car, but me. So check this out. Should I do it?
Put it in
Yeah,
park.
do it. You were on my sidewalk, by the way.
I was.
Probably.
Let's make your business more efficient together. Realtors, what if there was a tool that could help you simplify your business? If you hadn't heard of Rock Agent yet, you're missing out. Rock Agent gives you the power to easily calculate buyer and seller reports and impress all of your clients. All with just a few taps on your phone. It's your all-in-one tool for closing more deals and faster. Whether you're working with buyers or sellers, Rock Agent gives you the tools. You need to provide fast, accurate, and professional service.
Spit it out, Tim.
More, join my Zoom from the comfort of your. This was not a good idea. That didn't make no sense. People could turn you in. Take a ticket. You could go to jail. Oh no! What are we gonna do?
Attaboy, Timbo. Attaboy.
All right. I don't know who that was. The dialect, I don't know what that was. It's certainly not my dialect that I speak every day. But anyway, please come hang out with me. We're going to talk about video, equipment, software, have some examples. Would love for you to hang out with me. It'll be a great time. I appreciate all of you, and thank you for the opportunity to hang out here, Tim.
Timbo.
Heather, you're awesome.
Woohoo!
Thank you so much.
Woohoo!
I'll get you
All
back.
right, you get me back? All right, gang. Before the attorneys come up, just so you know, John Morgan, we haven't seen him in a while. I don't know if rates ever hit 5.5 in October like he said it would. I think it did on October 3rd from 12:30 to about 3 o'clock. It was like a 15-minute, 3-hour window where they actually hit 5.5. But actually, he's in the Southwest office today, okay? What I want to talk about real quick with, and I need help on this, is the best compliance TC gal I've ever known, and I mean that honestly. Half the stuff that I give you guys the answers to, just so you know, I get them from her. Just so you know, full disclosure, there's John, okay? He's doing a class, actually, a business planning class on the 16th. Well, I'll tell you a little bit more about that. But Maria wants to talk a little bit about rentals, because you guys are killing it with rentals. Who's not doing rentals? I mean, I know we don't, we're not big fans of them as realtors. We want to make the big bucks.
Carrie won't
But
get the referrals.
But we've had, Brandon Snyder's probably done 100 of them this year. 100, probably. Well, maybe I'm exaggerating a little bit, but pretty close. Carrie's done a ton. Both Carries have done a ton. So, but we have some money issues with paying you.
You always have money.
Yeah. That's the only time you talk is when there's the money issues here, okay?
Is because of these money
Uh-huh.
Okay, so just one thing that we're gonna cover really quick on your rental BBRAs. As an example, if you wanna collect $600, $300 for the tenant, $300 from the landlord. So your BBRA, your rental BBRA has to say 600. Are we all good with that? Right? Good. Okay. The second thing is that is happening is because you're taking that $600 and you're splitting it, 300 from the landlord, 300 from the tenant.
So this is when we have the rental listing.
No.
No.
This is when you are a tenant.
I represent the tenant.
You represent the tenant. So your BBRA says $600. You're gonna collect $600
From my tenant, and 3 from the property manager.
and 3 from the property
Okay,
manager.
gotcha, okay.
Okay? So when that situation comes up, what ends up happening is I end up getting 2 checks, one from the tenant and then one from the landlord, okay? Most of these checks, and you can come up and see these if you want, they will have on the bottom of here, voided after 90 days. Okay? So you need to make sure that you're in contact all the time with that tenant, because once that tenant gets approved for that property, you need to go and collect that $300. Because right now, we've got 2 agents that have lost $600 because the landlord's check is now void. The property manager is saying, I gave you 90 days, you should have been able to, get this handled in 90 days. We don't want to recut the check. And I can't get the check from the tenant. So without the check from the tenant and without the check from the landlord, I can't process, because then we don't have a file. So I can't process the tenant's check, I can't process the landlord's check without the tenant's check. Okay? So make sure, as soon as they get approved, get that money, because otherwise, we're seeing it where, all of these in here, they're all checks from landlords, but I've got nothing from the tenant. So without that being together, we cannot process. And so that means that you may end up losing, like these 2 agents did, this whole $600. So you did that for free. Okay?
Maria, what if the tenant they get the property, they're approved, property management sends the check, and then the tenant just refuses to pay you the check? Could you just change the?
You're gonna have to change the BBRA,
Yeah.
on it, so it'll just say.
At least you get half of it though,
$300.
Right.
Yeah, and we're seeing that, that's, the 2 agents that lost the $600 was because of that. The tenant just decided, we're not gonna pay. So that's where you need to make that decision at that point. What are you going to do? Are you just gonna say, okay, Mr. Tenant, fine, no problem, just initial here, reduce it from the 600 to the 300, have them initial it, and then we can process. But you need to let me know so that I can process, because right now, I just put little stickies on there that says waiting for tenant's, check.
Can you collect the $300 before the tenant is approved, like when you take them out?
You need to, you need to have a property identified, and stuff, because otherwise, what if they decide they can't, they're not gonna become a tenant, or they decided to buy, or they decided to, go somewhere else, go back to California, whatever. So you need to have a property identified, then as soon as you do, you collect the money. But we're having issues with agents really not following up with their tenants. You ask them, oh, hey, I've got a check here from the landlord. Oh, I had no idea that tenant got the property. Well, now you're behind the 8 ball because now it's 30 days later and we don't have the tenant's money. And so for you to go 30 days later and collect it, that's where it's hard. But if you find out from that landlord that it's been approved, you make that phone call before they even move in and say, hey, we've got this BBRA, you owe me the $300. It's either gonna be cash, not cash, but check or a money order.
But for your time taking them out and they change their mind, you cannot hold that check that before, if they change their mind and say that they don't want it or something, their circumstances changes, it's your time, it's our time taking them out. You still can't hold that check for them? You still can't hold that check for us to get
Can you get paid if they never rent a property, is what you're saying?
That's what I'm asking.
Okay.
What do you think?
A flat fee?
What do you think? So I meet you, you write a check for $300, a month goes by, you never rent anything. Can I keep that money?
No.
Why not?
If they zelled it.
No, you can't keep the money. The money only goes to Maria because we have to match it up to a property. If there's no property, then it goes to Tim's piggy bank money.
But I thought you
Or
could
Wendy's.
charge someone after 3 houses per house, no?
No.
No, because you don't have.
We're not lawyers. We don't work on contingency here, or whatever, or retainer, I mean.
Before you can collect that money.
But I'm with Linda, leaving compliance out of the way. Sorry, but me as an agent, I want to go. Okay, Julio, I'm going to help you rent the property. My fee is $300. You sign the seller BBRA, and I say, Julio, once we identify a property, as a matter of fact, Julio, write out a check right now to Realty One Group, okay? And then when you get a property, I'll put the address on the bottom. That's what I want to do as a realtor.
Yeah.
But I don't know if we can do that. Yeah, see, she's telling me no. But part of me wants to do that.
In my case, everything's paid by the landlord.
Yeah.
So what you can do is work an agreement that when he pays, like it's $3,000 a month, you charge him $300, he pays the landlord $3,300, and the landlord pays you all of it.
That's only if you're listing that, if you do
Right.
a courtesy listing.
If you have a listing,
Yeah.
right.
Then we're not talking about that. We're talking about you being solely the tenant's agent.
Right. And really the issue is, I don't want to say the agent is not strong enough, but the agent is not strong enough to go back to that tenant and say, look, you owe me $300. You agreed to it, you got to pay me. I mean, you don't want to do it quite that way, of course, but you should. They agreed to it, they signed it, and some agents are saying, oh, Tim, they're going to pay me next month. Or they're going to pay me $150 next month and $150 in January. No, we're not a bookkeeping, We're not going to keep that money for you and pay you in March of 25, your $150. So get that money as quickly as you can.
Yeah, and that's why as soon as they identify that property, you need to get that money from them, okay? And don't wait until they move in, because at that point in time, you're 30 days into it, and the odds of you getting that money is next to nil.
Would you advocate you picking up the keys and delivering them and get the check?
Well, that's, again, if you're listing, you're doing a courtesy listing, but if you're the tenant agent, that's done
Yeah, it's
through
cool.
the property management company, so you wouldn't see that, you wouldn't have that leverage. If you're the listing agent, that's a different story. But we're talking about a tenant's agent, and that's where we're having the issue. When you're in the landlord position, where you're dealing with the landlord and you're doing a courtesy listing, you can, have a more leverage, because obviously you'll have that with the landlord. But this is a tenant situation, okay? Any questions?
In my situation, I collect and I pay that potential.
Yeah, but you're listing.
Again, you're on the listing side, Fred, yeah.
We're not talking about a tenant
Yeah.
situation.
But I just want to protect myself.
So, okay, any questions? Yay.
Yay, thank you, Maria. Yeah, run to the door, right? Get me the hell out of here, right? All right, most of you know Alex Mihai, our corporate attorney, who makes an appearance either virtually or live a couple times a year. These are the guys that do the grunt work here in town, Jeff, Andrew, and Lucian. So really good guys. They come from this law firm with all the names on it, and we're kind of lucky to have them. We really are, okay? They're accessible. We call them, they answer the phone, and it's unbelievable. It really, really is. I mean, we're fortunate. I remember working for some companies in the past to get the attorney for the Remaxes I was with, it was like pulling teeth. It was like days go by and they might call you back. So here, these guys are real accessible. So that's Jeff, that's Andrew, that's Lucian. Ladies and gentlemen, say hello to everybody. Here we go. This is for you if you need that. That'll flip you through.
Let me get started just by thanking everyone. We appreciate the opportunity to come in and have a conversation with you. I believe we were here 3 or 4 months ago, and it's our goal to be here regularly. Once a quarter would be great, probably would be more like twice a year. But the idea is for us to be another familiar face, someone that you know is a resource for you and can really share our experience, our knowledge, our time in the litigation field to help you with your everyday practice. So that's why we're here, and that's why we will continue to come back, again, to kind of share our experience and help you, with your everyday transactions. I know these meetings can be long. We're not going to take too much time today, especially since it's not necessarily the most fun topic. But we will be about 30 minutes, and we want to share what we think is going to be some helpful information for you. We'll do some intros. We're going to cover an overview of the litigation process. What does that look like? What does it entail? What are some of the components of that process? And in the event you ever do get sued, what are some of the things that you may have to do or participate in with our assistance? And we will be there every step of the way. Most of those cases are professional negligence cases. Andy's going to talk a little bit more about what those are, what they look like, and really how they develop. So that's going to be another part of what we'll talk about. And then NRS 645, which really governs the duties of an agent. And that's what these plaintiff attorneys love to cite to in reference when they file an actual legal complaint. And throughout that complaint, there'll be a number of references to NRS 645. So we're going to show you what that statute looks like. Maybe you're already familiar with it. And then we'll highlight some of the sections that really come into play for a lot of these lawsuits. Practical strategies, some advice that we can provide to maybe help you in your everyday practice, documenting your file, keeping an organized file, making sure your communications are in a format that can be produced later on. For example, email is always going to be better than text message, even though most clients maybe prefer text message now. If it's something really important, you're probably going to want to do an email instead of text. But we'll talk about that as we go through the presentation. And then we'll try to save a little bit of time for Q&A. First though, I'm Lucian. That's an old picture. I wish I still look like that. I don't think I do, but I've been a lawyer for 18 years. And I've been with Bremer, White, Brown, and O'Meara for all of those 18 years. Over that time, I've done nothing but civil litigation. I've done real estate litigation, personal injury defense. I've represented a lot of large contractors in construction litigation, whether it's general contractors, subcontractors, wrongful death cases. Pretty much every type of civil litigation matter you can imagine is something that I've worked on. And I've been doing this for 18 years. Jeff is also a partner with Bremer, White, Brown, and O'Meara. Similarly, he's been practicing 16 years and has a wide variety of experience similar to mine. Frankly, we've worked on some of the biggest construction defect cases in Nevada, cases involving $100 million disputes, $80 million disputes. And we've been working on the Realty 1 cases now for several years and developed a really good working relationship with Alex Mihai, your general counsel. Andy, huge part of our team. Andy's been a lawyer for 12 years. He really gets involved on the ground floor in these cases. And if you do end up being involved in a lawsuit, Andy will be one of your primary contacts. He's going to talk a little bit this morning again about NRS 645, what that means, and how it impacts some of the cases. But the reason all three of us are here today is to let you know, we work in teams, so in the event you are ever facing a lawsuit or litigation, It's not gonna be one attorney, it's not gonna be a paralegal. The three of us work together as a team, and you get the whole team, you know, and that's something that hopefully makes you feel good and you know, eases your mind in the event that you may get sued down the road. Again, our goal is to help you avoid that.
Okay, I'll
Reality
see now.
is, lawsuits happen. A little bit about the firm. You know, we're in California, we're in Nevada, Arizona, Colorado, and Texas. We have 9 total offices. I'm currently the managing partner of the Nevada office, and here in Las Vegas, we have about 27 lawyers. In that nice building, that was the first slide. We have about 27 lawyers here in the Las Vegas office. I also helped open our Denver, Colorado office, where we have 10 lawyers. Again, we focus on civil litigation, a lot of real estate litigation. We really have 2 main goals. You know, by coming here and having these discussions, there's really 2 main goals that we want to accomplish. One, like I said before, we want to give you some tips, some tools, some advice that will help you avoid litigation. I mean, that's goal number 1, because the process itself is not fun. So goal number 1 is to help you avoid it. Goal number 2 is if it does happen, we want to give you some knowledge and input that'll help you be comfortable with the process, you know, that you already know some of the things that are gonna take place as part of the litigation. So those are really our 2 main goals. But with that, I'm gonna pass this off to Jeff, and he's gonna kind of get into a little bit more detail about the process and how the litigation works.
Pretty much.
Good morning, everyone. My name is Jeff Saab. Thank you so much for being here today. We appreciate your time. As attorneys, we wear many different types of hats. But the thing that I do, that I love doing the most, is helping folks like yourselves. So many times, I will meet with a client, and you know, a lawsuit doesn't spring up out of nowhere generally. Something happens 6 months prior, a year ago, and it's in the back of your head, and maybe you're losing sleep at night, maybe you're not eating, and eventually you'll get sued. And it just ruins your life, right? Not only because in most instances you felt you didn't do anything wrong or that you did the best that you could, but it's the unknown, right? You don't know what's gonna happen. And so there are different phases in the pre-litigation process that I like, but what I really like is that first meeting with the client, because when they come in, they're just so scared. They don't know what to do, what's going to happen. And what I do is I endeavor to assuage any concerns that they have. And I've been told so many times, Jeff, thank you. I couldn't sleep, I couldn't eat. I feel now that I have an advocate, somebody in my corner. And what we do is we kind of take them through the process. We pull back the curtain a bit. We let them know what happens during the litigation process, and also what they can expect in terms of their obligations, how they participate in discovery, how we value the case initially, what they can expect to be doing, and how many times they're interacting with us. And so that's all part of that process. Now, pre-lit demand, there's some event that triggers that demand, right? There's something that our client did or didn't do, and there are different statutes of limitations. Breach of contract, written contract, 6 years. Oral, 4 years. Breach of fiduciary duty, 3 years. Personal injury, 2 years. We've had some cases where folks have gotten hurt in homes on showings. And so some event triggers and starts that clock. And generally before a lawsuit is filed, there's a pre-litigation demand. And what will happen is the aggrieved individual will put together a letter through their lawyer which states, hey, you did this to me, these are my damages, here's some backup, and I want $1 million, or I want your insurance carrier's policy limits. And while some cases do get resolved pre-litigation, a lot don't, right? And then that's where we come in. Now, pleading's a complaint, right? We're what's called the notice pleading jurisdiction, and that's generally where the aggrieved kind of outlines what their issues are, and we'll talk more about that later. In response, we file what's called a responsive pleading. That can either be an answer to the complaint, or it can be something like a motion to dismiss, which is basically a means of kind of short-circuiting the litigation process. Once the parties make an appearance in the case, then we go into the discovery phase. Parties make their initial disclosures. There's written discovery, which we'll talk about. Depositions, which are wild. I've probably been through 700 or 800 of them, some lasting 30 minutes, some taking 7 or 8 days in these $100 million construction defect cases. There's expert discovery. We retain experts on behalf of you folks as needed. We move on. Potentially, there's a motion for summary judgment. Once there's been a good bit of discovery conducted, we file a motion with the court that says, look, Judge, there's no genuine issue of material fact in dispute. There's no reason for this to go to the jury because we've got all the information we need to shut this case down now. The judge will make that determination. We have pretrial motions, which are called motions in limine. Those are generally exclusionary motions where you want to keep out certain testimony, certain documents that don't quite meet the evidentiary standard. Trial, we utilize the Arizona method in terms of voir dire and jury selection. Generally, it takes a day to pick a jury. I spend up to 5 in some instances. And jury selection is key in determining how the case kind of plays out. Sometimes we'll do psychological profiles on the jurors. It's very in-depth. The trial could be a bench trial where it's just a judge, or it could be a jury trial with jurors. And then once there's a final adjudication, there's an appeal potentially. And so general litigation, we have something called the 5-year rule from the filing of the complaint till there's a final adjudication. Generally, it's 5 years. There's instances where that time frame gets told, but you can go on for 5 years and then someone files an appeal and you go on for another couple of years. So litigation can take a long time. So while we will endeavor to shut these cases down as quickly as we can for you, we may all be in a relationship for a bit of time. So we may get to know each other fairly well. Okay, getting sued if it happens, the bar for filing a lawsuit is very, very low. So I talked about the statute of limitations, right? So if the case doesn't get resolved pre-litigation, a complaint will be filed. And basically the complaint is just a document whereby the aggrieved outlines the allegations. And as a notice pleading jurisdiction, they don't necessarily have to plead with specificity if it's just like breach of contract. But if it's something that involves an element of fraud, then they have to be very specific. And once they file a complaint, they have 120 days to serve you. They can serve you via personal service, some instances through the Secretary of State, sometimes via publication. But the main thing is, if you get served in some fashion, it's very important that you follow protocol to put Realty One Group on notice, because once you're served, there's only 21 days to file an answer. If you don't file an answer or response to pleading within the 21 days, the other side can take what's called a default against you. They'll get a default, and then they'll try to get a default judgment where the clerk of the court issues a certain amount of money against you, and that document gets recorded. So we need to know right away when you get sued. And what we'll do is we'll file what's called a responsive pleading on your behalf. It'll be an answer, it'll be a dispositive motion potentially. In the answer, we have limited information at the onset of the litigation. So we, based on your input, will provide general responses, and generally we deny liability to the extent that we can. We always want to be honest, but we're definitely advocates for you. And in some instances, there's just not an information from the onset. So we're not going to admit the things that we're not sure about. We can respond to an allegation in the pleading by saying, without sufficient knowledge at this time, deny, because we want to do what we can to protect you. We will also assert what are called affirmative defenses. These are defenses that you have to raise from the onset or you waive them down the road. And there'll be things like the plaintiff who is suing me, who's claiming all these damages, they failed to mitigate their damages, right? Or they were comparatively at fault. Because we are a modified comparative jurisdiction. So if the person suing you is 51% at fault, it's a complete bar to their recovery. They can't get anything from you. So we can file an answer, or we can file what's called a motion to dismiss to kind of short circuit the process. And earlier I talked a little bit about statute of limitations. And so let's just say someone is suing you based on breach of contract. Statute of limitations, I believe, is 6 years on that for a written contract. And they file the complaint against you 7 years after the fact. They can't proceed. Their claim is time barred. So we would file a motion to dismiss based on the fact that the statute of limitations is run. Discovery. So once all the parties make an appearance in the case by filing the answer to the complaint, the case proceeds. And if the case is in arbitration, if the value is $50,000 or less, we go into arbitration. If it's over $50,000, we're before the district court. And we'll either have an early case conference or an early arbitration conference where the parties meet. And what we do is we talk about the case, we formulate an agenda, we talk about how much time we think we need for discovery, and that all goes into a document. And once that's approved by the court, we get into formal discovery. And this is super important. So the parties, the plaintiff, the defendant, the co-defendant, they will all make what are called their initial disclosures. In pursuant to those initial disclosures, everybody identifies all the relevant witnesses, and they'll also produce relevant documents. This can get a little hairy because sometimes the plaintiff who is suing thinks everything is relevant, and they'll want, all your protocols, your training handbooks, they'll want your entire employee file. And we say, no, you don't get all that. This is a very simple issue, and these things are not relevant or proportional under the Venetian case to their case. So we're always fighting for you at every phase of litigation, so we will fight to keep that stuff out to the extent that we can. We also use discovery to help us determine who are the relevant witnesses. We will question them, and that's done by virtue of a deposition. And depositions can be mundane, they can be pretty exciting. It just depends. But basically, if we're representing one of you folks here, you'd be in a room with me, I'd be sitting to your side, the adverse attorney would be on the other side, and there's generally a court reporter taking everything down because your testimony is under oath and you carry the same type of penalty for perjury. And basically, you'll be asked questions, or we'll ask questions about the case in an effort to, better our position or increase our defenses. And we help you with that every step of the way. We don't just say, here's a deposition notice, show up. What we do is we endeavor to get you ready as best we can. We'll talk to you, you'll come into our office, we'll do a mock deposition prep session. I'll have one of my attorneys in my office pretend they're the plaintiff's attorney and just really grill the heck out of you, right? Just so you know what you're going to be in for and you'll know how to answer. Expert discovery, again, based on the case, we'll hire experts. We've got a group that we use that are great. They've testified multiple times before, and they're all experts in their field. So based on the nature of the case, we'll get you an expert that suits your needs. Depositions again, these depots can kind of make or break the case. Attorneys are always trying to frame the case up for dispositive motion or for trial. So these are super important, and that's why we spend a lot of time with you during these depositions. Now, when the deposition is done, you'll get a copy of the transcript, and we'll go over it with you if need be. You can change things, you can keep stuff as is, but I'd recommend keeping things as is, because if you make a big change, they can try to impeach you with that at trial. So it's important to keep that in mind. Now, Ian's going to talk to you a little bit about professional negligence and some of the other aspects. Hopefully, I didn't give you too much technical information, but again, my thought was to kind of pull back the curtain a little bit, just to let you know what you might be in for during the litigation process, but we walk you through every step of the way. So.
Before Andy gets started, just a couple of follow-ups there. So you might be asking, okay, a complaint gets filed, it ends up on my doorstep, a process server comes to my house, what do I do? So you'll always notify the company first. The company will then decide whether or not to bring us in, how to bring us in, that type of thing. So you don't have to worry about contacting us directly. And if you ever do get served with a complaint, if you ever do get served with an official legal document, always notify the company first, your branch manager, and let them know. And then they will kind of determine whether or not we're going to get involved, if it's something that we need to get involved in, or that type of thing. Chances are, if it's an actual complaint that's been filed in district court, then they're going to bring us involved, and then we'll contact you. We'll bring you to our office for an initial meeting and kind of have a further discussion on the things that Jeff just talked about. The other thing, a deposition, there's that photo of the room, the lawyer. Depositions can be in an informal setting most of the time. A lot of time it's in a conference room, and you'll have two lawyers sitting across from each other. The witness will be at the head of the table, and there'll be a court reporter. It's a very formal part of the litigation process, but sometimes it'll take place in an informal setting, which could maybe let you have your guard down. But if you ever are in a deposition, they're under oath, you're required to tell the truth under oath. And even though it may be in an informal setting, they are very serious parts of the process. Again, if you ever have to go through that, we'll walk you through the whole process. But again, logistically, you ever get presented or served with an official legal document, bring it to the attention of the company first, and then they'll determine whether or not to have this involved. So with that, Andy's going to get into a little bit more detail on the types of cases that we see.
Yeah, thanks so much. We wanted to give you some insight into the kind of cases that we handle involving real estate agents. And the main one we call professional negligence cases, where there's some kind of allegation that the agent breached some duty that's set forth in NRS 645. And they can actually bring a claim for that through the statute. NRS 645, 257 allows someone to file a lawsuit against a brokerage or a real estate agent alleging a violation of 645. And it's going to sound counterintuitive, but that's actually a good thing, because this means that the lawsuit is kind of steered through 645, where we have certain protections, certain limitations, certain defenses that we can use to help you. What it means is, and we've had this come up, sometimes attorneys will try to sue our agents under, say, a traditional negligence theory or some kind of common law theory. We say, no, any kind of claim has to be brought through 645. And that's because there's actually a provision, 645, 251, that says that you are exempt from most common law claims if the conduct alleged triggers a duty under 645. So to the extent that attorneys try to bring these common law claims, we can move to dismiss those using the tool that Jeff talked about and try to steer this through 645. And we feel like in doing that, it kind of puts the lawsuit on our turf, where we're in a better position to defend you. So in most of these cases, it involves some kind of defect. Person buys a house, something wrong with it, they file a lawsuit. In most cases, it's mold. It could be some kind of foundational issue, but that's usually what starts the process. And not only do they sue their agent, they'll sue the buyer's agent or the seller's agent as well. They'll sue the seller. They may sue also the property inspection company. So the lawsuits can involve a lot of different parties, and the claims might be different against each one of those people and entities. So NRS 645, your duties are set forth in subsections 252, 253, and 254, as you know. And I think we included this to show, obviously there's a lot there. 252 is kind of sets forth the general duties that you owe in a real estate transaction. Don't worry, we won't go through every single thing that's on there. 253 is very specific to cases where the licensees are from the same brokerage. There's some specific duties there. And 254 is very similar to 252, except it's tethered to a brokerage agreement rather than a real estate transaction. But the upshot is all of these duties in these statutes relate to either a real estate transaction or a brokerage agreement, one of those two things. And even that limitation right there is something that can help us, because we have cases where sometimes the plaintiff's attorney will try to use 645 as a means to seek relief for something that's unrelated. Like we have a case right now, I can't give a lot of detail about it, but the plaintiffs in that case are seeking to recover for some kind of post-purchase work that they wanted to do on the property. And we're coming back and saying, well, no, that's not part of the real estate transaction. It's not part of the brokerage agreement. So that claim cannot proceed under NRS 645. So that's another reason why we like to kind of steer these cases under this statute. So 645, 252 to 254 imposes a lot of duties on you guys, but there's really only two that come up a lot in these cases. That's the duty of disclosure and the reasonable skill and care duty. And it's starting with the reasonable skill and care, we know that that's amorphous. That's pretty general, right? You have to exercise reasonable skill and care. And of course, we're going to say that, just by the fact that, there was a defect that wasn't detected through the purchase process doesn't mean that you necessarily did anything wrong. And when it comes to the disclosure requirement, you're required to disclose, facts that are material to the transaction that you either know or should know through the exercise of reasonable skill and care. And again, just because there was something wrong with the property doesn't necessarily mean that the agent did anything wrong. But the key is, if you know something, obviously you have to present that. And wanted to give you some idea of the specific allegations that we see in these cases. And it's going to be a little bit different depending on whether they're made against the buyer's agent or the seller's agent. So the screen caps you have there are from a real case. I know there's a lot there. This particular plaintiff's attorney is pretty wordy, has very long complaints. And this is a case against the buyer's agent. And usually the upshot is the plaintiff is saying that the buyer's agent did something wrong when it comes to the inspection phase, saying that, hey, had you properly told me about what inspections to get, we would have found this mold condition and I wouldn't have bought the house. And you can see, and I won't read this whole thing, but they start by setting forth the actual duty. So under S645, 252, subsection 1 establishes the duty on the part of the licensees, including the defendants, to, among other things, disclose to each party in the real estate transaction, as soon as practicable, any material and relevant facts that the agent knows or should know, right? Just parodying the statute. And then saying that they breach these statutory obligations by failing to competently research the property, failing to properly advise as to the inspections that were prudent, and failing to advise to engage, an indoor environmental professional. So basically saying that this duty of disclosure was breached because, had you, got, imparted on the buyer how important these inspections are, they would have got the right guy and they would have found whatever was wrong with the house. The one on the right side of the screen is basically the same thing, but it's the reasonable skill and care duty, saying that by not having the buyer get these additional inspections, that breaches the duty of care. So the allegations are a little bit different against an agent representing a seller. It's usually saying, well, you should have known. You represented the seller, there's something wrong with this property, you should have known about it. In fact, that you didn't, that's a violation of NRS 645. And I want to be real clear. I mean, we obviously disagree with these allegations. These are, I just wanted you to see, what plaintiff's attorneys come up with. And of course, we defend you in these cases, and we say that, just because there's something wrong with the home doesn't mean you knew about it, doesn't mean you were hiding anything, doesn't necessarily mean you did anything wrong. But again, in these kind of cases, they tend to kind of shoot first and ask questions later, suing, as many different parties as they can.
I have a question.
Yeah, absolutely.
If you're a buyer's agent or a seller's agent, but you're protected, or you think you're protected under an LLC, does that help us?
Protected under an LLC? Can you explain what you mean?
Like if we have the LLC, can they still come after us, or aren't we protected by that?
Oh, if you're
Real estate business.
Yeah.
Our real estate's under.
Yeah, so they would probably they could name the LLC, but they could also name you individual agent.
Is that right? They
And,
still can then?
Yeah, just like in a
Okay.
lot of these cases, they'll name Realty One Group as a brokerage, but they'll also name the individual agent involved as well. So it doesn't necessarily make a huge difference, but that's their MO is to name as many people as possible.
I
So
see.
Yeah, depending on the context of the case, context of the litigation, they may name both the LLC and the individual, but more instances than not, we would work to get the individual dismissed and say the LLC is the relevant party.
Okay,
So,
that's great.
there are protections there, and that's why you set up an LLC, and they're in place for those types of protections. As we mentioned early in the process, the bar to filing the complaint is pretty low, so usually they'll name anybody and everybody that they can, and then we have to work backwards to get people removed from the lawsuit. So in that situation, depending on the context, the facts, we'd work to get the individual dismissed and tell them that the LLC is actually the relevant party in that type of situation.
You know, to add, you should be able to avail yourself of the corporate structure or status, but there are some instances where a plaintiff will allege alter ego and attempt to pierce the corporate veil, arguing that, you know, you are the entity personally, you're just using it for yourself. So just keep that in mind. Like I said, definitely if you're an LLC, we'll try to avail you to the protections, but there are means by which a clever plaintiff's attorney can try to maneuver around that. So,
Okay, thank you.
of course.
Now, I guess one thing that Andy was kind of alluding to is there are very specific attorneys in town that specialize in these types of cases. And when I say that, they specialize in asserting or bringing these types of lawsuits. So they use a lot of the same language, and they are pretty crafty in terms of how they use the statute, like 645 and the subsections, to their advantage and kind of put a spin on the case. So we see a lot of the same attorneys over and over and over again. A lot of the allegations do relate to water damage, mold, foundation issues, things that could be hidden that you have no idea, right? But they'll use the favorable portions of that very lengthy statute, and that's why we gave you the statute in its entirety. When the legislature puts these things together, they're voluminous, they're long, there's a lot of language, and a skillful attorney can pick and choose the parts that help support their claim, which means then we have to come back, pick and choose the parts that help us. But if you go back to the slide with the reasonable skill and judgment, I mean, really, that's what it comes down to. If you take anything away from today and you want to become familiar with what's out there and how these lawsuits develop, someone's going to try to make a claim that you should have disclosed something under 645-252 subsection 1 and the language under A right there, or there's that very broad language under subsection 2 that you shall exercise the reasonable skill and care with respect to all parties to the transaction, right? So when you guys are out there meeting with clients, showing properties, negotiating deals, think about all the situations where number 2 could come up, right? So the next part of what we're going to talk about is, okay, well, how can we protect you from that very broad language that's a part of the statute, right? And I guess the context of all that is, if you end up in a trial, it's really a matter of who can tell the best story, right? In order to tell the best possible story, you need documents, you need timelines, you need information, and that's going to be part of you keeping an organized file and really just doing the best possible job you can do every day in every single one of your transactions. So a little bit of additional context in terms of where Andy's going with the next 2 slides.
yeah, thanks for that. Yeah, so like Lucian said, there's reasons why we want this to be a 645 claim. It provides limitations and defenses. It doesn't just allow for unlimited liability, and it even provides things that you're not responsible for. Like 252 also says a licensee who acts as an agent in a real estate transaction, unless otherwise agreed to in writing, owes no duty to independently verify the accuracy the statement made by an inspector, and you have no duty to conduct your own inspection of the property. And that's something we can use to our advantage. Would they come and say, well, look, you know, even in cases where there was an inspection, the inspector missed something, that can't be imparted to the agent. I mean, it's spelled out right there in the statute. Just like you have no duty to investigate the condition of the property, that's up to the buyer. Yeah.
So, and we've been told this in the classes before, but as an agent going to the home inspection, does that imply that we would have a liability then because we were there for the inspection?
Just being there doesn't necessarily trigger that. I don't think that they could make that argument because, I mean, the statute says you're not responsible for it, whether you're there or not.
Yeah, so if a buyer said, hey, I'd really like you to be there for my home inspection, there couldn't be any liability put back on us just because we were present at the inspection.
Right, and I think I would focus on the word present, right? If you're just there observing, supporting your client, you're okay, right?
Yeah.
If you're gonna try to insert yourself into that inspection process and maybe direct the inspector, then you might be creating problems for yourself. And there are some really assertive personalities out there that can't just sit back and kind of watch the process. But just being present, I think you're safe. If you're there and you're trying to take some more assertive role, that's where maybe problems could come up.
Okay, thank you.
Yeah, and another part of the statute that's relevant to us is subsection 259, which says that you can't be held responsible for a misrepresentation made by your client unless you knew about it and you failed to disclose that to the other side. So again, the seller is the one responsible for filling out the SRPD, as you guys know. I mean, it even says that right on the form, that you guys can't fill that out. They have to fill it out. If they lie about something, there's a protection for you there, unless it's something that you happen to know about and fail to disclose. So these are tools we use, and Jeff mentioned motions for summary judgment. We gear our discovery toward filing a motion for summary judgment. The written discovery, the depositions, we want to elicit information from the other side that supports these kind of defenses that we could present to the court on a motion for summary judgment and say, look, there's something new in trial here on, right? The facts that we've uncovered support that our agent, as a matter of law, didn't violate any part of the statute, and we should win on the merits of that.
Two things to add here that I think are helpful and might clarify a little bit. In interacting with your clients and advising your clients, the safest thing, and it's going to sound simple and elementary though, is to tell them to always tell the truth and always be forthcoming. You know, if you're there and you're part of the conversation, let's say you're representing the seller and you're there with the buyer's agent and the buyer, and they're asking your client some questions, and your client starts to lie, and you know they're lying, right? Based on either what you know about the property or your prior conversations, that really puts you in a difficult position when you look at the language of 645, right? So the reality is most of the obligations when it comes to disclosures are on the seller themselves, right? And you guys probably have training on that, and you know that. But if you know something, and there's a direct question from either the buyer's agent or the buyer directed to you, you have to be truthful if you know something, right? Whereas if your client's gonna tell a different story, well then that puts you in hot water, right? So
how do you address that then?
well, you gotta tell your client throughout the whole process, right? You know, always be truthful, always be honest. If you ever have uncertainty, if you're ever unsure about something, if you're ever not clear about what to say, then let's talk about it first, right? And I know you want to stay out of that, but the safest advice always is going to be tell them to tell the truth, you know, and that'll help you a lot in order to kind of avoid some of this contradictory language that's in 645.
Yeah, so that leads us into some practical strategies, and Lucian mentioned a lot of this already. And I know it seems like common sense, but we have to stress how important it is to do things like documenting your file. And I've worked with a lot of Realty One agents over the couple of years I've been with the firm, and you guys are great at doing this. So for the most part, it's going to be keep doing what you're doing, but just know how important it is. One of the key things is you want to memorialize any kind of verbal conversation, especially if it relates to inspections or the SRPD or something like that. It's so easy just to follow up with an email. It's like, hey, today we discussed inspections. I know you guys provide the notice to buyer that has the mold notice in it, and it's there in bold uppercase letters saying like, hey, you should get a mold inspection. You can follow up on that in an email. Just want to make sure you receive the buyer's notice of disclosure. Please let me know if you have any questions about that. Also, if they decline an inspection, and look, that's their choice, but you definitely want to memorialize that. Send them an email confirming that they chose to decline it. Maybe say, these inspections are really important to determine if there's anything wrong with the property that we can't see. And that way, later, if they file a suit saying, oh, well, you didn't tell me about these inspections, we can say, yeah, they did. We've got it right there. Inspections themselves, we're seeing a lot of flip property cases where the seller buys a house, fixes it up, puts it right back on the market, and I think the plaintiffs, particularly their attorneys, are making the argument that these are kind of just, make a quick buck kind of flips where they're not really doing good work, where the seller kind of knows that maybe there's something wrong with the house, and they're just putting a new coat of paint on it and just getting it back on the market. So if you're involved in a case where, it's a flip, it's a company that bought the house and they're just, fixing it up to get it back on the market, those are cases that we see a lot of. So things like inspections, disclosures in those cases are going to be even more important. Another thing to support are contingencies. So if it's not in the RPA, it's not a term of the sale. So if there's some kind of contingency, some kind of term that's discussed among the parties, it's got to be written down in the RPA as a contingency, or else it's not part of the deal. And afterwards, if a party tries to enforce it, it's not part of the deal. It's not going to be possible. So
could it be in an addendum, like after the RPA was already written, and then parties agree to it, and they just make it an addendum?
Yes, as long as it's part of the RPA, then you're good.
Yeah, some type of writing. You need to document in some way, shape, or form. There's something called the parallel evidence rule, where if it's not documented, if it's not part of the actual written agreement in some type of written form, then you can't use evidence of that agreement in the litigation. So it's got to be documented, and obviously that helps us significantly. The last thing before we get out of your way and open it up to questions, in terms of practical advice, practical strategies, you really have a great team here. You have a lot of resources within your own company. We encourage you to continue to take advantage of that. These types of meetings, the trainings you do internally, the assistance you get from your management, really lean on your team, utilize your team. If you're going through a transaction and something seems off, you have questions, talk about it, internally or with people here that you trust and you can go to. But really continue to rely upon your team and all the things that happen within your company to give you that extra information and training. I think that'll help you a lot. From what I've seen, you guys have an excellent team. These meetings are great. It's a great opportunity to share information, which will also help you in your day-to-day. Yes?
Question, do you have representation in Southern California?
Yes, we do. We have several. We're in Newport Beach, we're in San Diego, and we're also in LA.
LA County?
Yeah.
Okay, and do you have like a half an hour, a lot of clients ask, right? Half an hour consultation over the phone, free, like some firms do it over the.
Yeah, most of us do. You know, we're gonna leave some business cards behind, so if you have questions in terms about individual stuff, like we started the presentation today, most of the work we do is for the company, and it's very specific to what we talked about today. But we're always available if you do have questions or there's some crossover issue that you wanna consult us about. Yeah, we're available, and we'll leave our cards behind for that purpose. Yes?
Okay, so what happens when the agent does breach their contract and they do lose the case? Okay, I'm sure that happens. Do they get their license revoked or removed or suspended or?
Yeah, we actually haven't seen that yet. So the other thing I was gonna say, I'm glad you brought that up. Probably in the last year, I'd say the last 12 months, more than half of the cases that have come our way and that we've worked on, we've been able to get dismissed at the very beginning stages through the motions that we talked about today. So we've had a lot of success in getting these cases thrown out of court early, and really Andy deserves a lot of credit for that. He does all the research and dives deep into that statutory language that is really important to that type of motion. If we don't get it resolved early, there's a lot of communication with the company and with Alex Mihai about trying to get to some type of resolution, monetary resolution with the other side. Because you really don't want to end up in a trial, and you don't want to end up in a trial that ultimately may impact your license or your ability to practice. So we've had, for now, knock on wood, complete success in resolving these early, whether through a settlement, monetary resolution, but mostly just getting them thrown out of court through a motion to dismiss.
And just one thing to add, so unless the conduct of the agent was egregious or there was some sort of nefarious intent, it's just ordinary negligence, you're probably fine. And above and beyond that, 99% of these get settled before trial. And what we will incorporate into the settlement agreement is a no admission of liability clause. So basically, we're paying on what's called a disputed claim. You're not admitting you did anything wrong, Realty One's not admitting you did anything wrong. Yeah, so that covers you. And those agreements also are confidential, so they can't take those and kind of show that to, you know, the governing board and said, aha, you did something wrong, so you're covered.
Objection, leading the witness.
I want to thank everyone again, you know, for giving us the opportunity to come in. I know a lot of this information, again, it's not fun. A lot of it's technical. It's, you know, a lot of legal terminology that we went through today. But again, our goal is to help you feel comfortable in the event that you do have to go through this process, and share a little bit of the information and knowledge we have to help you avoid it. We love the opportunity to come back and continue some of these discussions. Try to be a little bit more brief next time. But we really appreciate the opportunity and the invite, you know, that allows us to come in.
Thank you, guys. Thank you. Hey, just one thing I want to tell you guys real quick, we'll get out of here. And I've had 3 of these in the last 2 months. If you closed the deal 6 months ago, and you've represented the buyer, and the buyer, hey, Patrick, how you doing? You call the buyer in 6 months, just see how he's doing. Hey, Patrick, it's going great, but I don't know, dude, the roof, with that rain we had, the roof, you know, it leaked like a mother. I think the seller lied to us. I think there was a leak and he didn't tell us, all right?
Should have bought all the warranty.
You have to send me an email. This is really important. You have to send me an email that day about that conversation. Don't keep it to yourself. And then 9 months later, we get sued, and the E&O coverage, and maybe you guys can help me with this, Alex should tell me this, that we knew about this in June, but we got the lawsuit the following April, and the agent never told us, the Realty One, about it. Okay, so even if you think it's trivial, you think the other agent's full of shit, you know, they're just looking, email me. I have a whole file that I document all these things and send it to Alex and Myga Rock, she's the other attorney in California, and they keep track of all this stuff, okay? And if we get a subpoena one day, and that's the first time we've ever heard of it, we're gonna get a little pissed at you because you didn't tell us, you know, because there had to be some signs something was gonna happen, usually, okay? So don't say, I'm not gonna tell Tim or Wendy that, or I'm not gonna call Mark. Call us. Even if you think it's trivial, that it'll protect you. It really, really will, okay?
Even if they have a home warranty.
There you go, exactly.
That's really good advice, though, because with the insurance company and the professional negligence coverage and all that,
Yeah.
there's a duty to not only notify them of existing claims or actual claims, but potential claims. So if one of your clients is telling you they want to sue, or they're gonna sue, or they're thinking about suing, bring it to the attention of the company first, because they'll probably have to put the insurance company on notice of a potential
Right.
claim.
Mhm.
And the earlier you do that, the better, for sure.
Yeah, I think Alex has a running Excel spreadsheet of thousands of potential claims. I'm kidding. But 99 don't come to fruition. Or if they do, like Jeff said, they get resolved before it ever goes to trial or court. So hope you guys got something out of this today. I appreciate you guys coming again. Thank you very much, okay? Let's, pick a number, Jeff, from 1 to 18. No pressure, big guy.
15.
15. The winner is? Nobody. Pick another number.
17.
Keep going. Go lower. Think low.
11.
There you go. Oh, look at you. She wins again. There we go. Hey, just so you know, these T-shirts and stuff we give out, if they don't fit, go see Vianney. You can get a better size or a different color or whatever you want to get, you know. So, don't, Tim, yes, hang out, grab a bagel, and come back for Tim.
It'll be like 90 minutes. Joking.